Socrates v. Kumlik. Facts: on July 2, 2002, 312 out of 528 members of the incumbent barangay officials of the Puerto Princesa convened into a preparatory recall assembly to initiate the recall of Victorino Dennis M. Socrates. The members of the PRA designated Mark David M. Hagedorn, president of the Association of Barangay Captains, as interim chair of the PRA. The PRA passed a resolution declaring its loss of confidence in Socrates and called for his recall. Socrates filed a petition to deny due course to the recall resolution, but the Kumlik and Bank dismissed the case for lack of merit. Edward M. Hagedorn filed his certificate of candidacy for mayor in the recall election. Ma. Flores F. Adavo and Merle E. Jhojo filed a petition before the Kumlik to disqualify Hagedorn from running in the recall election and to cancel his certificate of candidacy. The petitions were all anchored on the ground that Hagedorn is disqualified from running for a fourth consecutive term. Having been elected and having served as mayor of the city for 3 consecutive full terms immediately prior to the instant recall election for the same post, the Kumlik declared Hagedorn qualified to run in the recall election. GR number 154512. Socrates sought to nullify the Kumlik and Bank resolution, which gave due course to the recall resolution and scheduled the recall election on September 7, 2002. Socrates cites the following circumstances as legal infirmities attending the convening of the PRA and its issuance of the recall resolution. Not all members of the PRA were notified of the meeting to adopt the resolution. The proof of service of notice was palpably and legally deficient. The members of the PRA were themselves seeking a new electoral mandate from their respective constituents. The adoption of the resolution was exercised with grave abuse of authority, and the PRA proceedings were conducted in a manner that violated his and the public's constitutional right to information. GR number 154683. Vicente S. Sandoval, Jr. sought to annul Kumlik Resolution number 5673 insofar as it fixed the recall election on September 7, 2002, giving the candidates only a 10-day campaign period. He prayed that the Kumlik be enjoined from holding the recall election on September 7, 2002 and that a new date be fixed, giving the candidates at least an additional 15 days to campaign. The court gave the candidates an additional 15 days within which to campaign. Thus, the Kumlik reset the recall election to September 24, 2002. GRNOS 155083-84. Petitioners Adavo, Jhojo, and Ale Vassale the Kumlik's resolutions declaring Hagedorn qualified to run for mayor in the recall election. The court ordered the Kumlik to desist from proclaiming any winning candidate in the recall election until further orders from the court. In the meantime, Hagedorn garnered the highest number of votes in the recall election with 20,238 votes. Rival candidates Socrates and Sandoval obtained 17,220 votes and 13,241 votes, respectively. Issue 1. The recall resolution was valid. Held yes ratio. Petitioner Socrates argues that the Kumlik committed grave abuse of discretion in upholding the recall resolution despite the absence of notice to 130 PRA members and the defective service of notice to other PRA members. The Kumlik, however, found that the proponents for the recall of incumbent city mayor Victorino Dennis M. Socrates sent notices of the convening of the PRA to the members thereof pursuant to Section 70 of the Local Government Code. Notices of the convening of the Puerto Princesa PRA were also sent to the following: a list of 25 names of provincial elective officials, print and broadcast media practitioners, PNP officials, Kumlik City, regional and national officials, and DILG officials. The court is bound by the findings of fact of the Kumlik on matters within the competence and expertise of the Kumlik, unless the findings are patently erroneous. In the instant case, we do not find any valid reason to hold that the Kumlik's findings of fact are patently erroneous. Socrates also claims that the PRA members had no authority to adopt the recall resolution on July 2, 2002 because a majority of PRA members were seeking a new electoral mandate in the barangay elections scheduled on July 15, 2002. This argument deserves scant consideration, considering that when the PRA members adopted the recall resolution their terms of office had not yet expired. They were all de jure sangguniang barangay members with no legal disqualification to participate in the recall assembly under Section 70 of the Local Government Code. Socrates bewails that the manner private respondents conducted the PRA proceedings violated his constitutional right to information on matters of public concern. Socrates, however, admits receiving notice of the PRA meeting and of even sending his representative and counsel who were present during the entire PRA proceedings. Proponents of the recall election submitted to the Cumlic the recall resolution, minutes of the PRA proceedings, the journal of the PRA assembly, attendance sheets, notices sent to PRA members, an authenticated master list of barangay officials in Puerto Princesa. Socrates had the right to examine and copy all these public records in the official custody of the Cumlic. Socrates, however, does not claim that the Cumlic denied him this right. There is no legal basis in Socrates' claim that respondents violated his constitutional right to information on matters of public concern. Thus, we rule that the Cumlic did not commit grave abuse of discretion in upholding the validity of the recall resolution and in scheduling the recall election on September 24, 2002. Issue 1. Hagedorn is qualified to run for mayor in the recall election. Held no ratio. The constitutional and statutory provisions have two parts. The first part provides that an elective local official cannot serve for more than 3 consecutive terms. The clear intent is that only consecutive terms count in determining the 3-term limit rule. The second part states that voluntary renunciation of office for any length of time does not interrupt the continuity of service. The clear intent is that involuntary severance from office for any length of time interrupts continuity of service and prevents the service before and after the interruption from being joined together to form a continuous service or consecutive terms. After 3 consecutive terms, an elective local official cannot seek immediate re-election for a 4th term. The prohibited election refers to the next regular election for the same office following the end of the 3rd consecutive term. Any subsequent election, like a recall election, is no longer covered by the prohibition for 2 reasons. First, a subsequent election like a recall election is no longer an immediate re-election after 3 consecutive terms. Second, the intervening period constitutes an involuntary interruption in the continuity of service. When the framers of the Constitution debated on the term limit of elective local officials, the question asked was whether there would be no further election after 3 terms, or whether there would be no immediate re-election after 3 terms. What the Constitution prohibits is an immediate re-election for a 4th term following 3 consecutive terms. The Constitution, however, does not prohibit a subsequent re-election for a 4th term as long as the re-election is not immediately after the end of the 3rd consecutive term. A recall election midway in the term following the 3rd consecutive term is a subsequent election but not an immediate re-election after the 3rd term. Neither does the Constitution prohibit one barred from seeking immediate re-election to run in any other subsequent election involving the same term of office. What the Constitution prohibits is a consecutive 4th term. The debates in the Constitutional Commission evidently show that the prohibited election referred to by the framers of the Constitution is the immediate re-election after the 3rd term, not any other subsequent election. If the prohibition on elective local officials is applied to any election within the 3-year full term following the 3-term limit, then senators should also be prohibited from running in any election within the 6-year full term following their 2-term limit. The constitutional provision on the term limit of senators is worded exactly like the term limit of elective local officials. The framers of the Constitution thus clarified that a senator can run after only 3 years following his completion of 2 terms. The framers expressly acknowledged that the prohibited election refers only to the immediate re-election, and not to any subsequent election, during the 6-year period following the 2-term limit. The framers of the Constitution did not intend the period of rest of an elective official who has reached his term limit to be the full extent of the succeeding term. In the case of Hagedorn, his candidacy in the recall election on September 24, 2002 is not an immediate re-election after his 3rd consecutive term, which ended on June 30, 2001. The immediate re-election that the Constitution barred Hagedorn from seeking referred to the regular elections in 2001. Hagedorn did not seek re-election in the 2001 elections. Hagedorn was elected for 3 consecutive terms in the 1992, 1995, and 1998 elections and served in full his 3 consecutive terms as mayor of Puerto Princesa. Under the Constitution and the Local Government Code, Hagedorn could no longer run for mayor in the 2001 elections. The Constitution and the Local Government Code disqualified Hagedorn, who had reached the maximum 3-term limit, from running for a 4th consecutive term as mayor. Thus, Hagedorn did not run for mayor in the 2001 elections. Socrates ran and won as mayor of Puerto Princesa in the 2001 elections. After Hagedorn ceased to be mayor on June 30, 2001, he became a private citizen until the recall election of September 24, 2002, when he won by 3,018 votes over his closest opponent, Socrates. From June 30, 2001 until the recall election on September 24, 2002, the mayor of Puerto Princesa was Socrates. During the same period, Hagedorn was simply a private citizen. This period is clearly an interruption in the continuity of Hagedorn's service as mayor, not because of his voluntary renunciation, but because of a legal prohibition. Hagedorn's 3 consecutive terms ended on June 30, 2001. Hagedorn's new recall term from September 24, 2002 to June 30, 2004 is not a seamless continuation of his previous 3 consecutive terms as mayor. One cannot stitch together Hagedorn's previous 3 terms with his new recall term to make the recall term a 4th consecutive term, because factually it is not. An involuntary interruption occurred from June 30, 2001 to September 24, 2002, which broke the continuity or consecutive character of Hagedorn's service as mayor. In Hagedorn's case, the nearly 15-month period he was out of office, although short of a full term of 3 years, constituted an interruption in the continuity of his service as mayor. The Constitution does not require the interruption or hiatus to be a full term of 3 years. The clear intent is that interruption for any length of time, as long as the cause is involuntary, is sufficient to break an elective local official's continuity of service. Adormio established the rule that the winner in the recall election cannot be charged or credited with the full term of 3 years for purposes of counting the consecutiveness of an elective official's terms in office. In the same manner, Hagedorn's recall term does not retroact to include the tenure in office of Socrates. Hagedorn can only be disqualified to run in the September 24, 2002 recall election if the recall term is made to retroact to June 30, 2001, for only then can the recall term constitute a 4th consecutive term. But to consider Hagedorn's recall term as a full term of 3 years, retroacting to June 30, 2001, despite the fact that he won his recall term only last September 24, 2002, is to ignore reality. This court cannot declare as consecutive or successive terms of office which historically and factually are not. Worse, to make Hagedorn's recall term retroact to June 30, 2001 creates a legal fiction that unduly curtails the freedom of the people to choose their leaders through popular elections. The concept of term limits is in derogation of the sovereign will of the people to elect the leaders of their own choosing. Term limits must be construed strictly to give the fullest possible effect to the sovereign will of the people. A necessary consequence of the interruption of continuity of service is the start of a new term following the interruption. An official elected in recall election serves the unexpired term of the recalled official. This unexpired term is in itself one term for purposes of counting the three-term limit. This is clear from the following discussion in the Constitutional Commission. Although the discussion referred to special elections for senators and representatives of the House, the same principle applies to a recall election of local officials. Otherwise, an elective local official who serves a recall term can serve for more than 9 consecutive years, comprising of the recall term plus the regular 3 full terms. A local official who serves a recall term should know that the recall term is in itself one term, although less than 3 years. This is the inherent limitation he takes by running and winning in the recall election. Davide, concurring and dissenting. The ponencia is then correct when it holds that the 3-term limit bars an immediate re-election for a 4th term. But I disagree when it rules that in the case of Hagedorn he did not seek an immediate re-election for a 4th term because he was not a candidate for re-election in the May 2001 election. It forgets that what would have been his 4th term by virtue of the May 2001 election was for the period from June 30, 2001 to June 30, 2004. The flaw in the ruling results from an apparent confusion between term and election, the root cause of which is the attempt to distinguish voluntary renunciation of office from involuntary severance from office and the term of office to which it relates. I wish to add that the Constitutional Commission debates on the issue of no immediate re-election after 3 consecutive terms for members of Congress clearly indicated that the no immediate re-election after the 3-term limit would equally apply to the elective local officials. This accounted for the immediate acceptance by the Committee on Local Governments of the aforementioned amendment of Commissioner Davide, which is now Section 8 of Article X of the Constitution. These debates clearly showed the intent of the Commission that the ban against an immediate re-election after 3 consecutive terms applies to the 4th term, i.e., the term immediately following the 3 consecutive terms, to be filled up by the regular election for such 4th term. For one to be able to run again after 3 consecutive terms, he has to rest for the entire immediately succeeding 4th term. On the next 5th term he can run again to start a new series of 3 consecutive terms. The dichotomy made in the ponencia between voluntary renunciation of the office as used in Section 8 of Article X of the Constitution and Section 43 of RA No. 7160 and involuntary severance from office is unnecessary, if not misplaced. From the discussion in the ponencia, the latter is made to apply to the banned term, i.e., the 4th term immediately following 3 consecutive terms. Speaking now of Hagedorn, he cannot have suffered involuntary severance from office because there was nothing to be severed. He was not a holder of an office either in a de jure or de facto capacity. He knew he was disqualified from seeking a 3rd re-election to office. Disqualification is, definitely, not synonymous with involuntary severance. Even if we concede that involuntary severance is an act which interrupts the continuity of a term for purposes of applying the 3-term principle, the rule laid down in Lonzanita vs. Kumlik, cited in the ponencia, page 17, is not applicable in the case of Hagedorn. The involuntary severance referred to in that case was one that took place during any of the 3 terms, hence, the term during which it occurred should be excluded in the computation. In the case of Hagedorn, no such involuntary severance took place during any of his 3 terms brought about by his election in 1992 and re-elections in 1995 and 1998. More importantly, the voluntary renunciation referred to in Section 8, Article X of the Constitution and Section 43 of RA No. 7160 is one that takes place at any time during either the 1st, 2nd, or 3rd term of the 3 consecutive terms. This is very clear from the last clause of Section 8, Article X of the Constitution, which reads, shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. The purpose of the provision is to prevent an elective local official from voluntarily resigning from office for the purpose of circumventing the rule on the belief that the term during which he resigned would be excluded in the counting of the three-term rule. In short, the provision excluded is intended to impose a penalty on one who flouts the rule or make a mockery of it by the simple act of resigning. Thus, applying it in the case of Hagedorn, even if he voluntarily resigned on his third term, he would still be barred from seeking re-election in the May 2001 election. Hagedorn cannot likewise avail of the ruling in Adormio vs. Kumlik because in that case Talaga did not win in his second re-election bid, or for a third term, in the May 1998 elections. He won in the recall election of May 12, 2000. Hagedorn, as earlier stated, fully served 3 successive terms. Mendoza v. Kumlik. For resolution is a petition for certiorari filed by petitioners Melanio L. Mendoza and Mario E. Ibarra, seeking to set aside the resolution of the Commission on Elections, dated August 15, 2001, in EPC No. 2001-5 and to declare respondent Leonardo B. Roman's election as governor of Bataan on May 14, 2001 as null and void for allegedly being contrary to Art. X. 8 of the Constitution, which provides that the term of office of elective local officials, except barangay officials, which shall be determined by law, shall be 3 years and no such official shall serve for more than 3 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of his service for the full term for which he was elected. After due deliberation, the court voted 8-7 to dismiss the petition. Vidug, J., joined by Inares Santiago, J., voted to dismiss the petition. He contended that as revealed by the records of the Constitutional Commission, the Constitution envisions a continuous and an uninterrupted service for 3 full terms before the proscription applies. Therefore, not being a full term, a recall term should not be counted or used as a basis for the disqualification whether served prior or subsequent to the 9-year, full 3-term limit. Mendoza, J., in whose opinion Sasaeng, J. joined, voted to dismiss the petition on the ground that, in accordance with the ruling in Borja, J.R. v. Kumlik, 295 SCRA 157, Arcos v. Kumlik, GR number 133639, October 6, 1998, Res. Manzanita v. Kumlik, 311 SCRA 602, and Adormio v. Kumlik, GR number 147927, February 4, 2002, a term during which succession to a local elective office takes place or a recall election is held should not be counted in determining whether an elective local official has served more than 3 consecutive terms. He argued that the Constitution does not prohibit elective local officials from serving for more than 3 consecutive terms because, in fact, it excludes from the 3-term limit interruptions in the continuity of service. So long as such interruptions are not due to the voluntary renunciation of the office by an incumbent. Hence, the period from June 28, 1994 to June 30, 1995, during which respondent Leonardo B. Roman served as governor of Bataan by virtue of a recall election held in 1993, should not be counted. Since on May 14, 2001 respondent had previously served as governor of Bataan for only 2 consecutive terms, his election on that day was actually only his 3rd term for the same position. Panganaban, J., joined by Puno, J., also voted to dismiss the petition. He argued that a recall term should not be considered as 1 full term, because a contrary interpretation would in effect cut short the elected official's service to less than 9 years and shortchange his constituents. The desire to prevent monopoly of political power should be balanced against the need to uphold the voter's obvious preference, who, in the present case, is Roman, who received 97% of the votes cast. He explained that, in Socrates, he also voted to affirm the clear choice of the electorate, because in a democracy the people should, as much as legally possible, be governed by leaders freely chosen by them in credible elections. He concluded that, in election cases, when two conflicting legal positions are of almost equal weight, the scales of justice should be tilted in favor of the people's overwhelming choice. Ajcuna, J, joined by Bellosillo, J, also voted to dismiss, arguing that it is clear from the constitutional provision that the disqualification applies only if the terms are consecutive and the service is full and continuous. Hence, service for less than a term, except only in case of voluntary renunciation, should not count to disqualify an elective local official from running for the same position. This case is different from Socrates, where the full 3 consecutive terms had been continuously served so that disqualification had clearly attached. On the other hand, Sandoval Gutierrez, J, with whom Davide, Jr., CJ, and Austria Martinez, Corona, and Callejo, SR, JJ, concurred, holds the view that the recall term served by respondent Roman, comprising the period June 28, 1994 to June 30, 1995, should be considered as one term. Since he thereafter served for 2 consecutive terms from 1995 to 1998 and from 1998 to 2001, his election on May 14, 2001 was actually his 4th term and contravenes Art. X. 8 of the Constitution. For this reason, she voted to grant the petition and to declare respondent's election on May 14, 2001 as null and void. Carpio, J, joined by Carpio Morales, J, also dissented and voted to grant the petition. He held that a recall term constitutes 1 term and that to totally ignore a recall term in determining the 3-term limit would allow local officials to serve for more than 9 consecutive years, contrary to the manifest intent of the framers of the Constitution. He contended that respondent Roman's election in 2001 cannot exempt him from the 3-term limit imposed by the Constitution.